Greetings and welcome, everybody. My name is Zach Sarkis. I'm the Executive Director of New York HempLab and one of your hosts. Today I'm joined by Board Member Jason Klimek and our colleague Mary Kruger of NORML, but Mary's not on at the moment. But you're joining us for session number 10 for the New York Cannabis Legalization Workshop Series, where we provide a pretty in-depth section-by-section review of the MRTA, the Marijuana Regulation and Taxation Act. So yep, this is our 10th week doing it. We still got some weeks to go. And we're entering today into Article 6, which is the general provisions that'll provide some amendments to what will preview us like what is allowed, what is not allowed from a different context, as well as some amendments to legal requirements and possibly even some overview of the tax structure. But we won't get to, we'll see where we get to today. As always, this platform is best when y'all ask questions. So Jason and I will be cruising through this, having a dialogue between ourselves, but also we welcome comments. Feel free to drop questions, comments in the chat and or into the Q&A, and we will be sure to take them in stride. And yeah, we just thank everyone for being here. I want to give a shout out to our founding sponsoring members, Harris Beach Law Firm, as well as our 2021 sponsoring members, Mad Hatter Hideaway Smoke Shop and the Wagner Firm PLLC. Also big shout out to our founding business members who've been with us from the start, Boyle & Code, Cannamill, the New York Cannabis Growers and Processors Association, Singer Farm Naturals, Forefathers Innovation, Tracy John Law Firm, Closed Loop System, Dawson Law Firm, and also our 2021 business members, Hellendale Dermatology and Medical Spa, Beacon Skiff Apple Orchards, No Wave, Plant Science Labs, EFPR Group, and CBRE. Jason, if you want to take a moment to introduce yourself as I take care of some stuff in the background, the microphone is yours.
Sure, thanks, Zach. I'm Jason Klimek. I'm attorney over at Woods OV at Gilman, focusing on cannabis and tax. Also a member of the board of directors for HempLab, NORML, member of the New York State Bar Cannabis Law Committee, and been kind of working on these issues for the past 3 years now, I think it's been. And happy to be here, help educate, and go through this law, which has produced a lot of questions. And it's kind of the unfortunate aspect of this is we don't have the regulations yet. So a lot of times the questions that people are really concerned about that really relate to them, we just don't know the answers because the law doesn't provide it and kind of has kicked it to the regulations. And just a little update for people who are on that don't necessarily know is that we were hoping or maybe even expecting the regulators to be appointed and confirmed by June 10th, which was the end of the legislative session. And it is now June 29th, and we don't have any regulators that have officially been, appointed or anything like that. Though I don't know that that's necessarily stopping draft regulations, although I haven't heard that specifically. But people could be working behind the scenes to at least keep the ball rolling, because the goal, I believe, was to get regulations out by August, September time, and we're about to hit July, so that wouldn't give them a lot of time, especially with what I imagine are going to be fairly in-depth regulations, because this is a very complex law. There are a lot of issues that have been kicked to the regulations. So the more time they can take, the better. But that August, September timeframe for the first draft is getting pretty close.
Appreciate that, Jason. I'm just taking care of one more thing, resending the invitation to Mary, having a little back end issue over there. All right, but yeah, let's dive in. So tell us a little more about what to expect in this Article 6.
So today, I believe this, depending on how fast we go, how much we cover, there's the talks about the legal aspects of it, or I should say the criminal aspects of it. What is criminalized, what isn't. The specific opt-out provisions, how that works. And then if we get far enough, I believe the tax portion is in this part, which, you know, is my kind of wheelhouse, that happy to go into depth if anybody has questions about that. And, you know, this is really just kind of like where it starts to relate to all the different aspects of the law. You know, they pull in the criminal, they're pulling in the municipal law, things like that, so that they can amend all those portions to fit the cannabis law into all of the laws of New York that are relevant. So it's a very, very broad article that just is kind of making this law harmonize with the rest of the law and implementing, you know, a lot of other important pieces, which would be like the criminal aspects. You know, as we've said many times, a big focus of this law was to ensure that people who have historically been disproportionately impacted by cannabis prohibition, that is no longer going to be an issue going forward. And that's a lot done through the criminal aspects of the law, where they are, you know, amending out cannabis as a controlled substance for New York purposes, allowing possession of up to 3 ounces in public, things like that, and, you know, things that we'll see as we go forward. But that was a huge part of this law that is covered into this general provisions part. It's not a specific, you know, article within the law.
Great, appreciate that. Yeah, and welcome, Mary Kruger. I saw that you made it on here.
Fashionably late as usual. Hello.
Welcome, welcome, welcome. So yeah, we're about to dive into Article 6. Mary, if you want to give yourself a quick introduction, and then we'll move forward.
Sure thing. So thanks again for having me, Zach. As Zach said, my name is Mary Kruger. I'm the founder and executive director of NORML. We are the Rochester affiliate of the National Organization for the Reform of Marijuana Laws. So we're a cannabis consumer advocacy organization and here to offer that perspective. So thanks again, Zach.
Yeah, of course. Happy to have you here. All right, so Article 6, General Provisions, section, it starts with 125, which is General Prohibitions, Restrictions. Then we'll go with Protection of the Use of Cannabis, Unlawful Discrimination, etc., Permits, Registrations, and License, things that haven't already been covered, lab testing permits, special use permits, local opt-out, penalties for violation, revocation of registration license, review by courts, illicit cannabis, persons forbidden to traffic cannabis, access to criminal history, etc. So, an injunction for unlawful manufacturing, sale, and distribution. So, a lot of different stuff here, but we will dive in starting at 125, section 125, general provisions and restrictions. Yes.
What, just to make a note for everybody, we intentionally skipped over the hemp extract stuff because the laws the regulations are still in the comment period. So we figured that, you know, it'd be good to hold off on that discussion until we see how the regs have been finalized and potentially impacted any of the law. So just as
I think that's great. So we finished Article 4 2 weeks ago. We've skipped over Article 5, the hemp extract bill, and now we're at Article 6. All right, so no person shall cultivate, process, distribute for sale, or sell at wholesale or retail, or deliver to consumers any cannabis product, medical cannabis, or cannabinoid hemp or hemp extract product within the state without obtaining the appropriate registration, license, or permit therefor required by this chapter, unless otherwise authorized by the law. No registered organization, licensee, or permittee, or any other entity under the jurisdiction of the board shall sell or agree to sell, deliver in the state any cannabis or cannabinoid hemp or hemp extract for the purpose of resale to any person who is not duly registered, licensed, or permitted pursuant to this chapter to sell such product at wholesale or retail, as the case may be at time of such agreement and sale. So pretty simple that, you know, only licensed folks can sell wholesale to licensed folks, unless otherwise declared. No registered organization, licensee, or permittee, or any other entity under the jurisdiction of the board shall employ or permit to be employed or shall allow to work on any premises registered or licensed for retail sale hereunder any person under the age of 18 in any capacity where the duties of such person require or permit such person to sell, dispense, or handle cannabis. Any employee 18 years of age or older, or and under 21 of age may not have direct interaction with customers inside the licensed retail store. No registered organization, licensee, or permittee or any other entity under the jurisdiction of the board shall sell, deliver, or give away, or cause, permit, or procure to be sold, delivered, or given away any cannabis product, or medical cannabis on credit, except that a registered organization, licensee, and permittee may accept third-party credit cards for the sale of any cannabis product, or medical cannabis for which the RO or the registered license or permitted to dispense or sell to patients or cannabis consumers. This includes, but is not limited to, any consignment sale of any kind. So that's an interesting one. So that means there will be no, consignment is something that's common with small shops. Someone will go to a retailer and leave their product on the shelf and say, all right, there's a 30-day consignment period, and you pay me at the end of that, or you pay when the product's been sold. So it's evident that only product that's been purchased up front can make it to the shelf, if I'm reading that correctly. No registered organization, licensee, or permittee, or other entity under the jurisdiction of the board shall cease to be operated as a bona fide or legitimate premises within the contemplation of the registration, license, and permit issued for such premises as determined within the judgment of the board. And no registered organization, licensee, or permit, or other entity under the jurisdiction of the board shall refuse, nor any person holding a registration, license, or permit refuse, nor any officer or director or any corporation or organization holding registration, license, or permit refuse to appear and or testify under oath at an inquiry of the hearing held by the board with respect to any matters bearing upon the registration, license, or permit, the conduct of any of the people at the licensed premises, or bearing upon the character or fitness of such registrant, licensee, or permittee, or other entity under the jurisdiction of the board to continue to hold registration, etc. So nor shall any of the above offer false testimony under the oath. Jason, can you pick up this next line? I'm just I gotta close the door real quick.
No registered organization, licensee, or permittee, or any other entity under the jurisdiction of the board shall engage, participate in, or aid, or abet any violation of any provision of this chapter or the rules or regulations of the board. It shall be the responsibility of the registered organization's licensee or permittee or other entity under the jurisdiction of the board to exercise adequate supervision over the registered, licensed, or permitted location. Persons registered, licensed, or permitted shall be held strictly accountable for any and all violations that occur upon any registered, licensed, or permitted premises, and for any and all violations committed or permitted by any manager, agent, or employee of such registered, licensed, or permitted person. As it is a privilege under the law to be registered, licensed, or permitted to cultivate, process, distribute, or sell cannabis, the board may impose any such further restrictions upon the registrant, licensee, or permittee in particular instances as it deems necessary to further state policy and best serve the public interest. A violation or failure of any person registered, licensed, or permitted to comply with any condition, stipulation, or agreement upon which any registration, license, or permit was issued or renewed by the board may, in accordance with this chapter, subject the registrant, licensee, or permittee to suspension, cancellation, revocation, and or civil penalties in accordance with this chapter as determined by the board. No adult use cannabis or medical cannabis may be imported to or exported out of New York State by a registered organization, licensee, or person holding a license and or permit pursuant to this chapter until such time as it becomes legal to do so under federal law. So that's a question that always comes up, is can we get things from other states? Can we import? Can we export? No. But it is interesting that New York built it right into the law that as soon as it becomes federally legal, they can. There are other states that aren't necessarily doing that. There are some that are. So it's interesting that they're already planning for interstate commerce, which is probably good, because if it were totally federally legalized, like alcohol or something like that, New York would almost immediately have to amend the law, because there would be a constitutional challenge if they didn't allow that. So it's good that they wrote it in there, but yeah, it's totally illegal until the federal law changes. So do not bring things over the border, do not send things over the border that contain, more than 0.3% Delta-9 THC. or total THC for New York purposes, being technical, or USDA purposes, I should say. Should it become legal to do so under federal law, the board may promulgate such rules and regulations as deemed necessary to protect the public and the policy of the state, including but not limited to prioritization and promote New York cannabis. That's going to be a tricky one. They're going to have to kind of do it like they did the alcohol laws, because again, you can't favor in-state businesses or else that violates the Commerce Clause, but you can do things like, oh, if you use 80% New York ingredients or something like that, we'll charge you less tax. That you can do. Further, all such cannabis or cannabis products must be distributed in a manner consistent with the provisions of this chapter. No registered organization, licensee, or any of its agents, servants, or employees shall sell any cannabis product or medical cannabis from house to house by means of a truck or otherwise, where the sale is consummated and delivery made concurrently at the residence or place of business of the cannabis consumer. So no like food trucks of weed, basically. This subdivision shall not prohibit the delivery by a registered organization to certified patients or their designated caregivers pursuant to Article 3. No licensee shall employ any canvasser or solicitor for the purpose of receiving an order from a certified patient, designated caregiver, or cannabis consumer for any cannabis product or medical cannabis at the residence or place of business of such patient, caregiver, or consumer. Nor shall any licensee receive or accept any order for the sale of any cannabis product or medical cannabis which shall be solicited at the residence or place of business of the patient, caregiver, or consumer. This subdivision shall not prohibit the solicitation by a distributor of an order from any licensee at the licensed premises of such licensee. Section 126, license to be confined to premises, licensed premises for which no license shall be granted, and transporting cannabis. A registration, license, or permit issued to any person pursuant to this chapter for any registered, licensed, or permitted premises shall not be transferable to any other person, to any other location or premises, or to any other building or part of the building containing the licensed premises, except in the discretion of the office. All privileges granted by any registration, license, or permit shall be available only to the person therein specified and only for the premises license and no other, except if authorized by the board. Provided, however, that the provisions of this section shall not be deemed to prohibit the amendment of a registration or license as provided in the chapter, a violation of this section shall subject the registration, license, or permit to revocation for cause. Where a registration or license for premises has been revoked, the board is in its discretion may refuse to issue a registration, license, or permit under this chapter for a period of up to 5 years after such revocation for such premises or for any part of the building containing such premises connected therewith. So they can, but it's not mandatory for 5 years. But just understand that that's a pretty severe penalty if it's actually imposed. Let's see. In determining whether to issue such a prescription against granting any registration, license, or permit for such 5-year period, in addition to any other factors deemed relevant to the board shall, in the case of a license revoked due to the sale of cannabis to a person under the age of 21, not otherwise authorized by this chapter, determine whether the proposed subsequent licensee has obtained such premises through an arm's length transaction. And if such transaction is not found to be arm's length, the official shall deny the issuance of such license. So what's that saying? That's saying if your business gets shut down and then you start a new business and try to transfer the license over and start again, they're going to look at that kind of thing. So that's kind of what they're looking at, is if it's a bona fide deal where a third party is just coming in and purchasing it, you're done, then they will probably or potentially approve that sale. But if you're just trying to get around the fact that your license has been revoked and you're in this 5-year holding period, they can look through that and deny it. So for purpose of this section, arm's length transaction shall mean a sale for a fee of all undivided interest in real property, lease, management agreement, or other agreement giving the applicant control over the cannabis at the premises or any part thereof in the open market between an informed and willing buyer and seller, where neither is under any compulsion to participate in the transaction, unaffected by any unusual conditions indicating a reasonable possibility that the sale was made for the purpose of permitting the original licensee to avoid the effect of the revocation. The following sales shall be presumed not to be arm's length transactions unless adequate documentation is provided demonstrating the sale, lease, management agreement, or other agreement giving the applicant control over the cannabis at the premises was not conducted in whole or in part for the purpose of permitting the original licensee to avoid the effects of the revocation. A sale between relatives, a sale between related companies or partners in a business, or a sale, lease, management agreement, or other agreement giving the applicant control over the cannabis at the premises affected by other facts or circumstances that would indicate that the sale, lease, management agreement, or other agreement giving the applicant control over the cannabis at the premises is entered into for the primary purpose of permitting the original licensee to avoid the effects of the revocation.
So all that is about, if someone has their license revoked, there's a lot of stipulation as to how they cannot get involved and how, the circles of influence and arm length transactions. So folks around them can't cover for them essentially, or do a workaround. That's what I'm hearing.
Yep, that's exactly what it is. So, if I have, if I get in trouble and then sell the company to my wife, they're going to look at that and be like, we know what you do. Unless it was a legitimate transaction where my wife wanted to start the business. I was completely stepping out of it. It was sold at fair market. If I can make it look, and it is an arm's length transaction at that point, then perhaps they will. But, the presumption is, no, you're just trying to skirt the law.
Mm-hmm.
All right. No registered organization, licensee, or permittee shall transport cannabis products or medical cannabis except in vehicles owned and operated by such registered organization, licensee, or permittee, or hired and operated by such registered organization, licensee, or permittee from a trucking or transportation company permitted and registered with the board. So I think we had discussed this before, but it seems like there will be a transportation, we'll call it, permit, not necessarily a license, but just something that, permits the transportation. Purely, you're just taking custody and delivering it from point A to point B, which is not a distributor. That is a function of a distributor, but it's not a distributor. And presumably because it's a permit, it may be easier to obtain than an actual license. So that'll be interesting, and I'm sure that will be covered in the regulations. All right, protections for the use of cannabis, unlawful discriminations prohibited. No person, registered organization, licensee, or permittee, employees, or their agents shall be subject to arrest, prosecution, or penalty in any manner or denied any right or privilege, including but not limited to civil liability or disciplinary action by a business or occupational or professional licensing board or office solely for the conduct permitted under this chapter. For the avoidance of doubt, the Appellate Division of the Supreme Court of the State of New York and any disciplinary or character and fitness committees established by law are occupational and professional licensing boards within the meaning of this section. State and local law enforcement agencies shall not cooperate with or provide assistance to the government of the United States or any agency thereof in enforcing the Federal Controlled Substances Act solely for actions consistent with this chapter, except as pursuant to a valid court order. So just to kind of clarify that, they won't cooperate, meaning they won't just willingly give over, but if you are subject to federal rules and regulations and, basically prohibitions on cannabis, that doesn't mean that, that protects you. That just means that New York won't voluntarily give it over, but your name's probably still in a database somewhere in New York. And if it's subpoenaed, it'll come up. No landlord may refuse to lease to and may not otherwise penalize an individual solely for conduct authorized under this chapter, except if failing to do so would cause a landlord to lose a monetary or licensing related benefit under federal law or regulation, or if the property has in place a smoke-free policy, it is not required to permit the smoking of cannabis products on its premises, provided no such restriction may be construed to limit the certified medical use of cannabis. So there is this seems to actually have changed, because prior it was they had to be listed on like the smoke-free like there's a website of smoke-free places, like they're registered with the state as smoke-free. This is just a smoke-free policy, so I'm not sure if that's the same, but I think this was a change. But basically they're saying you have to treat it like cigarettes. So if you totally prohibit cigarettes, then you can totally prohibit cannabis. If you don't, then you can't, and it's not going to apply to medical. Let's see. No school, college, or university may refuse to enroll and may not otherwise penalize a person solely for conduct allowed under this chapter, except if failing to do so would cause the school, college, or university to lose a monetary or licensing related benefit under federal law or regulation. That one's going to be huge because you can pretty much assume that, especially at the collegiate level, every school is getting some type of federal money. So that could be a huge, huge loophole right there.
Well, I wonder though too. So back to the landlord, if there's subsidized housing, can they, is it basically no smoking, or are they going to say you can't have urine and you can't have THC in your urine? As we said, you can't, like, when we're looking at the rules, and we'll see this again about how, like, basically piss tests are no longer a thing for THC in New York State unless there is a relationship to a federal entity. So here with the university or a landlord that's getting monetary benefits from a federal housing program, like, to what degree can they like splice that and have impact on the residents or students?
My guess, and this is purely a guess, is that it would be something like they would have an anti-cannabis policy so that they wouldn't, necessarily jeopardize their funding or whatever. And then if you were found to be in violation, they could take action against you. So I don't think that they're going to be affirmatively drug testing all of their tenants, all of the students, whatever the case may be. But if you violate that, they probably will be allowed to test you and then take adverse action because it's tied to federal contracting, money, licensing, whatever it is.
Well, what about the ability for any adult to have up to 5 pounds on their personal residence? Like,
so I don't know like HUD, Housing and Urban Development Federal Agency, rules and regs and laws and things like that. But my guess is you probably can't have controlled substances in those places. So I think that it's probably the same kind of idea that you can't do. They can prohibit those types of things of you can't have these controlled substances on the premises and things like that. But I don't really know. We'll have to see how this all shakes out. New York is actually very, very unique insofar as the protections they are providing. A lot of states, they don't provide protection, so employers can still fire you if you test positive for cannabis. Whereas New York, that's pretty much an absolute ban other than this federal issue. So, we'll have to see how that all shakes out. But, for schools, and things like that, the federal funding is there and they're going to be very protective. I mean, that's why we don't see a ton of cannabis research and testing in states that are legal, at big research universities and things like that, because they don't want to jeopardize any federal funding unless they go get the DEA license and do all that kind of stuff. So, yeah, it's a very touchy issue, but it'll be interesting to see kind of how it all shakes out. All right, or let's see, if the school, college, or university has adopted a code of conduct prohibiting cannabis use on the basis of a sincere religious belief of the school, college, or university. Let's see. For the purpose of medical care, including organ transplants, a certified patient's use of medical cannabis must be considered the equivalent of the use of any other medication under the direction of the practitioner. It does not constitute the use of an illicit substance or otherwise disqualifying a registered qualifying patient from medical care. So that one, apparently it looks like it doesn't cover recreational use. So if you're up for an organ transplant, become a medical patient. That's what that seems to say. Let's see. An employer shall adhere to policies regarding cannabis use in accordance with section 201D of the labor law. No person may be denied custody or or visitation or parenting time with a minor under the Family Court Act, Domestic Relations Law, or Social Services Law solely for the conduct permitted under this chapter, including but not limited to Section 22205 or 22215 of penal law, unless it is in the best interest of the child and the child's physical, mental, or emotional condition has been impaired or is in imminent danger of becoming impaired as a result of the person's behavior as established by a fair preponderance of the evidence. For the purpose of this section, this determination cannot be based solely on whether and when and how often a person uses cannabis without separate evidence of harm. So there is a rebuttable presumption that if you are using cannabis, you are still a responsible parent, but it's not a blanket, that you can do whatever you want. There's still the whole best interest of the child, things like that. But that was a big issue, I think, in other states. And I think even in New York under the decriminalization was that, it's not really like in New York, it wasn't a crime at that point, but still could be held against you in custody, visitation, hearings, things like that. So that's a very good addition.
Totally.
Yeah, that is, as are a lot of other pieces of this bill that we've been reading about, but that's an extremely progressive part of this bill. We haven't seen any consumer protection like that in any state that's legalized before us. So that's really huge that we're able to get that and more that we'll see here.
And I think it's kind of a sad commentary that like it's such a huge thing, but it's so obvious that it should be the case. Like it's legal. Like you're doing something that is legal. Like, could you imagine if alcohol had the same presumption that if you drink, we can hold that against you. Like even if you drink responsibly, you have a drink. Like it shouldn't be that big of a deal, but it is. But it shouldn't be because it's so logical that it should be that case. But good for New York putting it in there.
Yeah, especially when we've seen it used as a tool that just as so much of marijuana prohibition is disproportionately impacted people of color, specifically from low income communities. It's not everyone who these rules are being enforced with. It's really on a case by case basis. And from, data that we have and conversations that I've had in the past several years, it's not everyone who those policies have been enforced for up until this point. So again, it's extremely progressive. We were able to get this in here.
Yep. All right. A person currently under parole, probation, or other state supervision or released or on recognizance, non-monetary conditions, or bail prior to being convicted shall not be punished or otherwise penalized for conduct allowed under this chapter unless the terms and conditions of said parole, probation, or state supervision explicitly prohibit a person's cannabis use or other conduct otherwise allowable under this chapter. A person's use of cannabis or conduct under this chapter shall not be prohibited unless it has been shown by clear and convincing evidence that the prohibition is reasonably related to the underlying crime. Nothing in this provision shall restrict the rights of certified medical patients. Another very progressive piece, that just because you're out on parole and you're smoking cannabis doesn't mean that you're going to go right back, especially when it's legal. All right, permits, registrations, and licenses. No permit, registration, or license shall be transferable or assignable, except that notwithstanding any other provision of the law, the permit, registration, or license of a sole proprietor converting to a corporate form where such proprietor becomes the sole stockholder and only officer and director of such new corporation may be transferred to the subject corporation if all requirements of the chapter remain the same with respect to such permit, registration, or license as transferred, and further with the registered organization or licensee shall transmit to the board within 10 days of the transfer of the license allowable under the subdivision on a form prescribed by the board notification of such transfer of license. Very quickly, if you're a sole proprietor, meaning you have unlimited liability, like somebody slips and falls and now your house is up for grabs if you get sued. If you are just forming an LLC, you're going to be the only member, you can freely transfer your license to that LLC. You just have to give the board notice. All right. No permit, registration, license shall be pledged or deposited as collateral security for any loan or upon any other condition, and any such pledge or deposit and any contract providing therefore shall be void. Permits, registrations, and licenses issued under this chapter shall contain, in addition to any further information or material to be prescribed by the rules and regulations of the board, the following information. the name of the person to whom the license is issued, type of license, and what type of cannabis commerce is thereby permitted, description of the street and number or otherwise of the licensed premises, and a statement in substance that such license shall not be deemed a property or vested right, and that it may be revoked at any time pursuant to law. Laboratory testing permits. The board shall approve and permit one or more independent cannabis testing laboratories to test medical cannabis, adult use cannabis, and or cannabinoid hemp or hemp extract. Yeah, let's go with more than
one or more. I'm just biting my tongue. Like, oh my god.
Yeah, let's have as many as the market will bear. I think that might be the best policy. To be permitted as an independent cannabis laboratory, a laboratory must apply to the office on a form and in a manner prescribed by the office, which may include a reasonable fee, and must demonstrate the following to the satisfaction of the board. The owners and directors of the laboratory are of good moral character. The laboratory and its staff has skills, resources, expertise needed to accurately and consistently perform all of the testing required for adult use cannabis, medical cannabis, and or cannabinoid hemp or hemp extract. The laboratory has in place and will maintain adequate policies, procedures, and facility security to ensure proper collection, labeling, accessioning, preparation, analysis, result reporting, disposal, and storage of adult use cannabis and or medical cannabis. For the testing of cannabis, the laboratory is physically located in New York State, and the laboratory meets any and all requirements prescribed by this chapter and the board in regulation. The owner of the laboratory testing permit under this section shall not hold a permit, registration, or license in any category of this chapter, and shall not have any direct or indirect ownership interest in such registered organization or licensee. No board member, officer, manager, owner, partner, principal, stakeholder, or member of a registered organization or licensee under this chapter, or such person's immediate family member, shall have an interest or voting rights in any laboratory testing permittee. The board shall require that.
I feel like, sorry to interrupt you, that's like the first time I can remember seeing voting rights being explicit. You know,
and also person's immediate family member. Like, all
yeah, because it's all been adult children, or like, what's like adult children, like a spouse, but yeah, immediate is all family members, which is very interesting.
It's from a lawyer perspective, it's very interesting to see how these definitions, which maybe, on the surface seem very much the same. They're describing the same type of thing, but all of these little differences between them, I mean, hypothetically could, really mean that there are actual differences that hopefully will be, more explored in the regulation. But the fact that like they keep changing it almost seemingly every section just makes you wonder, like, what are the limitations or not the limitations based on, they changed this little wording or added that little thing. It's, I don't know. Without the regulations, it's, from a lawyer perspective, it's very frustrating.
Truly.
All right. The board shall require that the permitted laboratory report testing results to the board in a manner, form, and time frame as determined by the office. The board is authorized to promulgate regulations establishing minimum operating and testing requirements and requiring permitted laboratories to perform certain tests and services. A laboratory granted a laboratory testing permit under this chapter shall not require to be licensed by the Federal Drug Enforcement Agency. The board is authorized to enter into contracts or memoranda of understanding with any other state for the purpose of aligning laboratory testing requirements or establishing best practices in testing cannabis. Would you like me to
take? I can take a jump. Sure. Section 130, special use permits. The board shall have the authority to issue temporary permits for carrying on activities consistent with the policy and purpose of this chapter with respect to cannabis. No special use permit shall extend for a period longer than 90 days and shall not be renewable except where a permit is being issued to a licensee as defined in Article 4 of this chapter. Special use permit shall be issued pursuant to an abbreviated application process. The special use permit holder shall have 90 days in which to become fully licensed by satisfying all of the remaining conditions for licensure, which were not required for the issuance of the special use permit. So is what I'm hearing, like, could you read that as like you could get a special use permit as a doorway into your full license? And I'm asking that under the context that there's a lot of special use permits out in California that have not been actually transferred formally into the adult use market. And there's a big push. I think the county of LA just like put $100 million into trying to get people under like specifically special use permits to get them to be legit license holders. So I'm curious what that's all about there.
It certainly could, but there is clearly this 90-day period, and that's it, because the permit holder shall have 90 days. Like, that's not discretionary, and you can't renew it. But like, it's also interesting because like with the trucking permit, like when we had read previously, they kept referencing permit without saying, well, yeah, but eventually you really need to use like licensed. And what like is that a distributor license? Because again, distributor license kind of implies more than just transporting from A to B.
Totally.
So yeah, This is kind of where like I feel like, you know, they were kind of working on different sections and didn't necessarily harmonize everything with the law itself.
The board may set reasonable fees for such permits and make rules and regulations to implement this section. So 1, industrial cannabis permit. To purchase cannabis from one of the entities licensed by the board for the use in the manufacture and sale of any of the following when such cannabis is not otherwise suitable for consumption purposes, namely apparel, energy, paper, and tools. B, scientific, chemical, mechanical, and industrial products. Or C, any other industrial use as determined by the board in regulation. So I'm like, yeah, that's interesting. So basically what I hear there is you could take THC products and use it for an industrial purpose, which I think is important and interesting. But we'll see what that turns into. 2, trucking permits. To allow for trucking or transportation of cannabis products or medical cannabis by a person other than a registered organization or licensee under this chapter. Warehouse permit. To allow for the storage of cannabis, cannabis products, or medical cannabis at a location not otherwise registered by or licensed by the office. A packaging permit. To authorize a licensed cannabis distributor to sort, package, label, and bundle cannabis products from one or more registered organizations or licensed processors on the premises of the licensed cannabis distributor or at a warehouse for which a permit has been issued under this section. It's like, why the heck do you need a special packaging permit to do what I would say is a processor or a distributor rule?
If you could be like a supplement, like if for some reason there was just a really busy season, maybe, I don't know.
Yeah. So there's a question. If you have a license from N Brown, if you have a license to produce edibles, does each batch have to send out to a lab to be tested, or just the oil or butter being used? Well, currently what I'm experiencing in the hemp processing market, I have to get a COA on my flower. Then I send it to my extractor. They extract. They have to get a COA on the extraction. And then they make the product and have to get a COA on the final product as well. And so that's what because they want to, there's no, that on reception or on initial processing allows them to know that, they got to know what the chemical constitution is. They also need to know there's no toxicity, no microbes, no pesticides, etc. And also, not always is product always, it's not always going to be used at once. So that's a batch. That one extract that was like processed could be considered a batch or a lot. And it gets put into a product. And then you got to know how many milligrams are in a serving of an oil or butter being used. So that's how I imagine it working. Welcome any other thoughts?
I think that's probably accurate because, you got to, like you said, you got to make sure at every step where you're introducing potentially things, you got to check to make sure. I mean, if you're using a rosin press, you probably know exactly what's in it. But if you're using a chemical extraction method or anything, you got to make sure all the solvents are out of there. So yeah, I imagine that it's going to be a lot of testing, but it's consumer safety, and I think that's where the government's coming from is, we need to make sure these products are safe.
All right, I agree with that. And just look at this next section, section 131. This is a big topic right now. If any of you are down on Long Island, like our friend Dave Felkowski, who's part of the NYCGPA. There's a lot of folks who are working hard against local opt-out. And we'll see here that there's a certain time window where municipalities need to plant the seed of their opt-out or declare opting out, but we'll get there in a moment. So local opt-out, municipal control and preemption. The licensure and establishment of a retail dispensary license or on-site consumption license under the provisions of Article 4 of this chapter authorizing the retail sale of adult use cannabis to cannabis consumers shall not be applicable to a town, city, or village which, after the effective date of this chapter and on or before the later of December 31st, 2021, or 9 months after the effective date of the section, adopts a local law subject to permissive referendum governed by Section 24 of the Municipal Home Rule Law, requesting the Cannabis Control Board to prohibit the establishment of a such retail dispensary license or on-site consumption license contained in Article 4 of this chapter within the jurisdiction of the town, city, or village. Provided, however, that any town law shall apply to the area of the town outside of any village within such town. No local law may be adopted after the later of December 31st, 2021, or 9 months after the effective date of this section, prohibiting the establishment of a retail dispensary license or on-site consumption license, provided, however, that local law repealing such prohibition may be adopted after such date. So if I'm reading that right, they got to have their proposal to opt out by December 31st, 2021.
Yeah, I mean, it's a dense provision. There's a lot in there. There's that. So it's, December 31st is the cutoff date. But they can always repeal that prohibition later. Also, subject to permissive referendum, meaning that they can enact the opt-out, but if somebody wants to put it to a public referendum to determine whether or not they can opt out, whether the opt-out will be effective, they can do that. And then also a conflict between, what happens if a village is within a town and the town opts out, but the village doesn't want to. Well, that says that the village has its own say in the matter.
Yep, great. I'm glad you clarified that. Also, Mary Kruger just shared with everyone a link to the New York NORML, a toolkit for avoiding opt-out. So if you think opt-out is an issue in your municipality or region, it's a great toolkit put together by the New York chapter of NORML to help keep people informed and engaged as to how to avoid opting out, if that's something you are fighting for. Except as provided for in the subdivision of this section, all county, town, city, and village governing bodies are hereby preempted from adopting any law, rule, ordinance, regulation, or prohibition pertaining to the operation of or licensure of a registered organization, adult use cannabis licensee, or cannabinoid hemp licenses. However, towns, cities, and villages may pass local laws and regulations governing the time, place, manner of the operation of a licensed adult use cannabis retail dispensary or an on-site consumption site, provided such law or regulation does not make the operation of such licensed retail dispensaries or on-site consumption sites unreasonably impracticable as determined by the board. That was a mouthful. 131A, office to be necessary party to certain proceedings. So the office shall be made a party to all actions proceeding affecting in any matter the possession, ownership, or transfer of a registration, license, or permit to operate within a municipality and to all such injunction proceedings. And then 132, penalties for the violation of this chapter. Any person who cultivates for the sale or sells cannabis products or medical cannabis without having the appropriate registration, license, or permit therefore, or whose registration, license, or permit has been revoked, surrendered, or canceled may be subjected to persecution in accordance with Article 222 of the Penal Law. Any registered organization or licensee who has received notification of a registration or license suspension pursuant to the provisions of this chapter, who sells cannabis, cannabis products, medical cannabis, or cannabinoid hemp or hemp extract during the suspension period shall be subject to persecution as provided by Article 222 of the Penal Law, and upon conviction thereof of this section may be subject to civil penalty of not more than $500 or $5,000.
Let me just point out real quick that all of these illegal behaviors are conditioned on the sale. So that is really what the law is getting at, is if you have an unlicensed sale. It's not the growing, it's not the possession, it's not even the transfer, it's just the transfer for money. And I think that's an important point. And kind of like brings up a question that I've had is, technically you're not allowed to grow cannabis right now, but you are allowed to possess it. What exactly is the punishment? And it's just kind of a rhetorical question. What is the punishment for growing cannabis right now? I don't know, because possession is legal. So, that's one of the questions. And, there were any criminal lawyers on, I'd be happy.
And it also begs the question too about, like, if the plant hasn't been harvested yet, is it Delta 9 or is it THCA? Is it total THC? And at what point in time it's harvested? And that creates a whole nother level of complexity in itself. Any person who shall knowingly make any material false statement in the application process for registration, license, or a permit under this chapter may be subject to a license or a registration suspension, revocation, or denial subject to the board, or may be subject to a civil penalty not more than $2,000. Any person under the age of 21 found to be in possession of cannabis or cannabis products who is not a certified patient pursuant to Article 3 of this chapter shall be in violation of this chapter and shall be subject to the following penalty. 1, the person shall be subject to a civil penalty of not more than $50. A civil penalty shall be payable to the Office of Cannabis Management. 2, any identifying information provided by the enforcement agency for the purpose of facilitating payment to the civil penalty shall not be shared or disclosed under any circumstances with any other agency or law enforcement division. B, the person shall, upon payment of the required civil penalty, be provided with information related to the dangers of underage use of cannabis and information related to the cannabis use disorder by the office. I tell you, whoever gets the contract for making the pamphlet that educates those civil penalty recipients about the dangers of underage use, there may be a real quick niche market there, folks.
Ancillary businesses.
Ancillary businesses, yeah. And C, the issuance and subsequent payment of such civil penalties shall no way qualify as a criminal accusation, admission of guilt, or criminal conviction, and shall in no way operate as a disqualification of any such person from holding public office, attaining public employment, or as a forfeiture of any right or privilege. Cannabis recovered from individuals who are found to be in violation of this chapter may, after notice and opportunity for a hearing, be considered a nuisance and shall be disposed of or destroyed. After due notice and opportunity to be heard as established by rules and regulations, nothing in this section shall prohibit the board from suspending, revoking, or denying a license, permit, registration, or application in addition to penalties of the section. 133, revocation of registrations, license, permits for cause, procedure, revocation, or cancellation. So actually we're at the 12:55 mark. Should we take a pause here?
Sure. Looks like a B section.
Yeah, it does. And I think we're about to get this. It's probably I think one of the last sections of this, but obviously there's nothing huge new here besides the civil penalties that we've seen. Curious, does folks have any questions or thoughts before we transition out of this off this call today? Mary, you got any thoughts, questions, perspective?
I just want to add my thoughts about home cultivation right now. I am 99% sure, after just looking at the way that the current criminal law is written, that it is pretty clear that you cannot start growing cannabis until 6 months after the law has passed if you hold your medical card, and there is up to 18 months after the first legal sale for adult use is made that they have to put regulations in place for adult use cultivation. So just want to clarify that.
Oh yeah, I totally agree. My question is just, what's the penalty? Because if possession is legal, then what's the penalty for
there is in the criminal law, and I'll double check with David Holland from New York NORML about this, but I'm pretty sure in the criminal law there's a difference in penalty for cultivation versus possession, because there's different sections of the criminal law for possession versus cultivation. It's like 222.05 versus 222.15. So I believe there's different penalties for the different acts.
Yeah, this is, I know nothing about criminal law. If anybody ever gets in trouble with the law, do not
contact New York NORML.
Yeah, do not call me. You do not want me as that lawyer. Got tax
Jason's
problems?
our tax guy. Jason's our tax guy. David's our criminal guy. So
Yeah.
contact NORML. We got you.
We have a question about, have board members been announced? Assuming for OCM and CCB? No, not that I have heard.
No.
We're still, what is it, 19 days overdue? So
Impatiently waiting.
Yep. And yeah, all that we have heard, I think so far, is that neither Norm nor Axel are going to be executive director. But I think that's, and I don't think that's actually official. That's just, I think, kind of the unofficial rumor. But yeah, I think that's really it. I don't even think there's been too many names thrown about for potential regulators and things like that, which is really a shame. Like it should be more of an open process to make sure that we get, good regulators in there, because as we've seen going through this law, so much is going to be up to the regulations.
Yep. Agreed. Definitely a lesson for other states to learn from us, to make sure that there's something in the legislation to make this process of appointing the regulators more transparent, because it's all behind closed doors right now.
Mm-hmm.
Totally. Well, folks, that wraps up another workshop series. Number 10 is in the books. Allison, Brian, Carlos, Jessica, Matthew, Melissa, and Brown, and all those who are watching this after the recording, thank you for being here. Thanks for your support. Mary and Jason, thank you so much for your perspective and time. And yeah, big shout out to our sponsoring members, Harris Beach Law Firm, Mad Hatter's Hideaway, and the Wagner Firm. Appreciate your help and us keep the Zoom call rolling. And we will see you all next time. Take care.
Thank you, Zach.
Yep. See ya.
Bye.
Bye.